Welcome to the Realtist Report. I'm your host, Dearborn member, real estate broker, Darryl Powell Lee. Today's guest is Calvin Boyd of Boyd Law LLC. How you doing today, Calvin?
How's it going?
Good. For our Realtist members who aren't familiar with you, of course I am. We've done several transactions, and those in the real estate circle definitely know of you. Before our Realtist members and viewers that don't know about you, tell them a little bit about yourself.
Okay. My name's, as Mr. Lee, Powell Lee just stated, my name's Calvin Boyd. I own a law firm here in Chicago, Illinois by the name of Boyd Law LLC, specializing in real estate and landlord-tenant issues. I went to Michigan State University for undergrad, where I got a BA, and I went to Michigan State University College of Law, where I got a Juris Doctor degree, specializing in business, real estate, and litigation.
Outstanding. And how long have you been practicing?
4 years.
4 years. Okay. And do you work for a is Boyd Law your firm, or do you share it with someone? How does that work?
Oh, Boyd Law is my firm. I created it, and I have it's a staff of 2, and I have a legal assistant. And we focus on a lot of real estate transactions, and it's been a great journey into entrepreneurship and very rewarding.
Outstanding. So, and this is episode 2, by the way. In episode 1, we had Demetrius Cole of Illinois Greater Title.
I know Demetrius.
Right. And we talked about title insurance and why that was important. And I think that segues into our episode with you, because I guess that intermediary between the title company and the buyer or seller would be the attorney.
That is correct.
Right. Could you tell me a little bit about what that relationship is between, we'll start first with the title company. What is that relationship between the attorney and title? How do you guys work together?
Okay. So what generally happens is that an attorney is solicited, or the attorney decides to work with a particular title company. And when I say work with, that means that there is like a contractual relationship where we actually do sign documents formalizing our relationship and saying that I, as the attorney, will be a title agent for the title company, which means that I will pull title generally in the sale transactions when the attorney is representing the seller.
Okay.
Then at that point, I guess duties, if you would like to call them that, would be triggered. And that attorney would pull title from the title company that he has a relationship with. It's common for attorneys to have multiple attorney agent relationships with multiple, title companies.
Okay.
And we would pull the title, examine title to make sure that the title that, our client, right, when representing the seller, when we pull the title, to check the title to make sure that our client is actually going to give good title, so that the title company can issue what's called an insurance policy, and insure against the any loss that the buyer may incur.
Okay, so we did cover the insuring the property, insuring the title with Demetrius Cole in episode 1. You used a phrase that many may not be familiar with, which is pull the title, right? So let's walk back a little bit for those that didn't see episode 1, right, and are just tuning in for episode 2. Let's start with the basics. What is title?
Okay. So title is a legal word that we refer to, meaning that for you to have ownership of the property, right? So like take this pen. If I were to say here on TV that, hey, I'm going to give Darryl, who's sitting to my left, I'm going to give him this pen, and I said, hey, this is yours. We know, because he's holding that pen, that means that he has title to that piece of property,
okay.
Right? Now we can't do that. I can't say, okay, here's a piece of land, Darryl. This is your land, right? Because it doesn't work like that. It's hard to be able to tell, because he can't, have it on his, physical person, his body, to know that he owns the piece of property. So what happens is that we have the way we show that title is transferred from one person to another. We use a tangible piece of paper, and we record it with the recorder of deeds office in whatever jurisdiction that you may be in. Jurisdiction just means a particular place. So we write up what's called a deed. There are many different types of deeds, and I won't bog you down with that.
Okay.
In the situation that I gave you when we pull title, right? We would have a look at the title report, so that we know that the person who is going to sign the deed and give it to Darryl, that they actually have title, and they are actually able to give title. And the chain of title reports are on your recorder of deeds in their web on their website. So we generally go to the title company who has, I guess, a more extensive database, and they can find things that an ordinary person wouldn't be able to find. And we access that database. We have a look at the title report. We go through and perform all the checks and balances to ensure accuracy. And then at that point, a title commitment is issued, which means that the title company is willing to issue a policy subject to the terms and conditions in the title report, and ensure the transaction, which is a very good step in the right direction with respect to a real estate transaction.
Got it. So, for our Realtist members and viewers, is title and deed the same thing? Can I have my name on the title but not my name on the deed?
Yeah, I think they're interchangeable. They're the same thing. Title, I would say title and deed. A deed is how you convey title, right? A deed is a document that, like I said, is recorded. So, yeah, it's the same thing.
It's the same thing.
Yeah.
Okay.
Yeah.
All right. And your relationship with different title companies, we've talked about, why it's important to have an attorney on that side to represent you in talking to these title companies. But your relationship with the buyer or seller, let's have a conversation about that, because as I understand, and Mr. Cole said in the last episode that every state does not require you to have an attorney, but Illinois does. If I'm looking to buy or sell a property, why do I need an attorney if there are other states out here that don't have it?
Because the data shows, and you can look this up. I mean, I don't have any footnotes for you, unfortunately, but the data shows that with respect to accuracy and in terms of doing like the due diligence, right, the title searches before a transaction is made, and when it comes to drafting the documents, the deed can get complex in terms of, say, it could be pretty simple if you have one person who's going to buy the property,
okay,
versus if you have two people who are going to buy the property. There's certain language that has to be in that deed when conveying title, and the fact that you have an attorney ensures the accuracy because we are trained to be able to handle these types of tasks.
Understood. So we've spoken about title. Where are some of the other areas where an attorney would come into play? As a real estate broker, I know that in every transaction, I have my clients. If I'm representing the buyer or I'm representing the seller, I always have an inspection done, and in that inspection, I try to discern all of the things that may be wrong with a property from the buyer or seller side. But just speaking for the buyers, if I find that there's a myriad of things that need to be fixed in that property, and I want to ensure that they get fixed, can you talk to me about how, as an attorney, you can facilitate that to ensure that happens?
Definitely. And I like to make a statement about inspections because I've recently encountered a wave of clients who wanted to take the word of a seller whom they had known personally. But I will pretty much say that I don't recommend doing that. I mean, this isn't legal advice, but you should always have a professional inspection performed. Daryl knows that we can't force a potential or a client to do that,
right,
but you should always have an inspection performed so that you know what you're getting yourselves into, because a lot of times the purchase of a house or a building as an investment property is the biggest transaction that a lot of people tend to make in their lifetimes. So, but with respect to what you said in terms of you say we've gotten past the inspection report and we're under contract, mm-hmm, and we have a contract and the purchase is going to be facilitated. What the buyer's attorney would do as well as the seller's attorney would do, there's a 5-day period from the date of acceptance, like once the contract is accepted and the parties are together, where they it's called the attorney review and inspection period, and during that timeline, that's where documents go back and forth, whether they be emails or an actual letter, where certain things are requested. Maybe it's a credit for a reduction in purchase price, so that whatever issue or defect in the property or problem with the property is I guess corrected,
right,
and the buyer is happy.
Got it. So I send you, and we're actually working backwards. This was not the plan. We're actually working backwards in the transaction. We kind of started at the closing table at where we are at title, and now we're backing up to the inspection and review period. And I guess we'll start, or we'll end rather, with where the contract begins. But in this attorney review period, contract is submitted. My offer is $285,000. I'm representing the buyer. The seller accepts that. We're in the attorney review period. And is my client, is the buyer mandated to purchase that property after that offer is accepted?
I'm gonna say yes, but based on the attorney review period and the new multi-board contract, I mean, the buyer can get out of the contract if they don't like the contract, but it has to be for good cause. It can't be for purchase price alone, right? You can't have cold feet. Once you make that offer legally, you have to stick to it. But during the attorney review period, and let me know if I'm getting ahead of myself, the attorney is going to review the contract, line by line. He's going to look at the disclosures that are attached to the contract.
Okay.
And the attorney is going to advise the client of any modifications that need to be made to the contract, right? Because that's what we're here for. That's why it's good to have an attorney, and that's why Illinois, does a good job of requiring that an attorney is needed to facilitate a real estate transaction.
So in that attorney review period, and we'll talk specifically about inspection. If we find out that there's no plumbing in the house, there are no pipes, there's nothing behind the walls, under the floor to facilitate water going through that property, would that be considered something, a topic, an issue where we can say, you know what, we want to back out of this contract because there's no plumbing inside of this property? Would that be something that we can use?
Definitely, because that would be a material defect in the property, right? Because generally speaking, prior to going under contract and making an offer, you would take them through the property, the client or the buyer through the property,
Right.
for them to have a look at the property. But then if at the inspection period, and if this wasn't disclosed already, right?
Okay.
The disclosures, I mean, that we found out that there's no like HVAC system or no pipes. I mean, that's a material defect in the property, which is a serious problem with the property, is what material defect means. And I don't think any any reasonable purchaser would expect to buy a house after going through a walkthrough and say, oh, by the way, there's no pipes inside.
Right. Right.
And that's gonna be a huge burden for anyone to go and install all of these things.
Absolutely. So if I understand you correctly, if these things are not disclosed by the seller, hey, there's no piping in the home, there's no electricity, and not just power, but wires to facilitate electricity. There's none of that in the home, and none of these things have been disclosed. Then there's an opportunity for the buyer to back out of that contract because this is considered a material defect.
That is correct.
Okay.
And
go ahead.
And on the other side, right, there's the
Yes.
seller side, and the seller has to be very careful to disclose these things, because if they don't disclose these things, then that could be grounds for what'll result in a lawsuit in court.
Got it. So let's talk about something I see often that sellers have in their contractual agreements, which is as is, right? I see that often when dealing with buyers, dealing with sellers. There's a phrase in that contract, in that offer contract, that reads as is. Can you tell me a little bit about, from the legal perspective, what is as is and how it applies to a transaction?
Definitely. So as is means that the buyer is willing to take the property subject to, or not subject to, I guess I don't want to use that word.
Okay.
The buyer is willing to take that property as is, and how it sounds, with any type of court cases or building code violations that may be pending, and as well as the condition of the property. And it pretty much tells the buyer that during the attorney review period, pretty much don't ask for anything, because we don't want to do anything, and we want you to just take the property as is and to wrap up the transaction.
Understood. So when we were just having a conversation about material defects, does as is that a blanket phrase where even if there are material defects inside the property, the buyer's obligated to still go through with the transaction?
Well, it would depend. It would depend. I would say no. I mean that they could
Okay.
still get out because I mean, say if you have a professional inspection and then you find out that there are things that maybe you're an investor, right?
Yeah.
You see a lot of investors buy properties as is and they're going to turn the property around, and then after you get under contract, you have a professional inspection and you determine that hey, I knew that this property had problems, but I didn't know that. Based on my front end or preliminary review of the building, I didn't know that the ground was sinking or something like that.
Okay.
And so then that would be a basis to be able to to get out of the contract.
Got it.
Yeah.
Understood. So, as is does not protect the seller from major material defects inside the property. So, if my client signs a contract with an as-is clause and finds out that the roof is in need of major repair, because they initialed as is on that contract does not mean that they have to go through with that transaction. Do I understand you correctly?
Yes. That is I mean, that's debatable, but
Right.
I would say yes.
Okay. In your experience, have you encountered situations where a client has not gone through with the purchase of the property? And if so, could you tell me a little bit about what happened in that transaction, why they may have not gone through with the purchase of that property?
Oh, definitely. So I've had scenarios from one end of the spectrum to the other, where I mean, there's something that you generally put down. I guess it's not required, but any smart seller of property, right,
Okay.
would require that the buyer deposit what is called earnest money to show it's like a good faith deposit that'll be applied to the purchase price or the closing costs at the end of the transaction. So in this scenario, the client made the deposit and there wasn't a basis under the contract, right? We had gotten past the attorney review and inspection period, and the client just wanted to cancel the transaction just because they no longer wanted to live in that area. And unfortunately, that isn't a basis to be able to to cancel the contract,
Right.
because the seller's on the hook, and they're expecting to close.
Okay.
They have their own deadlines to meet as well, just as the buyer does.
Right.
So under that situation, generally speaking, the earnest money is forfeited as what's referred to as liquidated damages, and the seller is able to walk away with the earnest money. So that's what
Wow.
happens in those situations.
Wow. So I guess we've had a conversation about the buyer and where there is valid reason for them to back out of the contract. But if there isn't a valid reason to back out of the contract, then the seller can keep that earnest money.
That is correct.
And is it a percentage? Is it they keep the whole thing? Like how does that work? So if a client puts down $5,000 in earnest money to purchase this property and then realizes that that house on the corner of the block, I don't think I like the people that are living there. I don't want to buy this property. That buyer can't get that $5,000 back?
I would say, generally speaking, no. I don't know any attorneys who would be willing to just give it back. I mean, you do have some attorneys who would be able to say, maybe we'll give them half back or something like that.
Okay.
But I would say that trust me, there's like a lot of disputes about this very issue, right? A lot of back and forth about it. But I would say that the seller would be in that scenario would be
Right.
entitled to the entire thing.
That's amazing information. Realtist Nation, I hope you're paying close attention when it comes to transactions. When you as a buyer decide to make a purchase, understand that you are giving earnest money in good faith that you're going to purchase that property, and know that that earnest money may not be returned if not for a valid reason such as a material defect, right, to back out of that contract. If it's for reasons of anything other than that, right? Is material defect the only a cause for termination of a contract, or are there other things that can terminate that contract?
Definitely other things like during the attorney review process, right? We talked about professional inspections. The other I like to look at them as safeguards.
Okay.
Right. So there's a professional inspection, right? Then there's the attorney review, and where you can terminate the contract if you don't, if you don't like the contract, but it can't be based on purchase price alone. So that could be a number of things, right? And then there's a safeguard, assuming that you're purchasing the property, and and you're going to obtain a loan from a bank.
Okay.
And under that scenario, say that the appraisal price, because the bank is going to perform an appraisal, because if they're going to give you the money to purchase a piece of property, it's an investment for them. So they want to make sure that the money that they give, they want to make sure that the investment is worth it for them, just in case that if the buyer loses the property and they have to go to mortgage foreclosure court, they want to make sure that they're going to be able to get all or some of their money back, or a substantial amount of their money back. So if the bank is going to send an appraiser, someone to appraise the property, someone who they trust, and to determine the value. And if the purchase price that's listed in the contract is under the appraisal, generally you're not going to be able to get a loan from the bank. And so under that hypothetical, right, that would be another way for you to get out of the contract, as long as you comply with the deadlines, because that's called the mortgage contingency clause, and which means that the transaction is contingent upon the buyer receiving a mortgage. And it gets more specific than that, but I won't go into the details of that.
So if an appraiser comes in to a property that I intend to purchase, right? So I'm loving this property. I offered $350,000 on this property. My offer was accepted, but and I'm getting a loan from a bank. The bank sends an appraiser out. The appraiser takes a close look at the property and the surrounding properties and decides that this property is only worth $300,000. Then, according to you, I have a legal out to not go through with the purchase of this property because the appraisal came back lower than what I had agreed to pay. Is that correct?
That is correct. When you go through that is correct. That's correct. I just want to be clear about that.
Right.
But there are some other scenarios where you may have the seller who comes in, and the seller may say, we'll give you a price reduction.
Okay.
$300,000. In that scenario, I would say that the buyer is still on the hook. If there's a modification addendum, what we call it as an addendum to the contract.
Right.
Sent over to both sides, and they agree to reduce the purchase price, then I would say that the buyer is probably, still on the hook to go through the transaction.
Understood.
Yeah.
Understood. So, appraisal, material defect, these are two of the major things that will decide if a transaction goes through or not, right? So, Realtors Nation, you want to be clear that the property needs to appraise at the purchase price in which you intend to buy it. You also want to make sure that there are no major defects, and if they are, to explain that to your attorney and let them know that this is a deal breaker for you. Material defects, appraisals that don't come back properly, these are deal breakers, things that you can use to break a contract. I wanted to talk to you about trust. I hear this often in real estate circles. When you purchase a property, you want to put it in a trust. Can you tell Real Estate Nation, Realtors Nation, what trust is?
Right. So a trust is what it generally is. It's commonly referred to as a land trust, which it pretty much converts a piece of real estate to kind of like personal property for the benefit of the beneficiary. So I like to look at it, though, as something where I've seen my clients use it, something to obscure title to, so that the true identity of the property or the owner of the property is hidden away in public record, and the trust is only listed as the owner of the property. It kind of makes the property hard to find, and there's a number of reasons as to why one might want to do that.
Okay. So. So if I understand trust, if I put this property in a trust, the way I understand it, let's say there is a personal lawsuit against me. If I have my properties in a trust, are they subject to coming to court as compensation for whomever is suing me?
Well, if you're the beneficiary, then I'm going to say no.
Okay.
I've seen I mean, there's some really creative things out there,
Right.
to be able to find it and to maybe, get it inside of there.
Right.
But I would say, no, that, you would be, as a beneficiary, you really only have, like a limited like interest that then the property is technically like, I guess, like not yours. It's only like temporarily.
Got it.
So I would say that if you were hit with the lawsuit, then you would be fine unless. Well, I don't want to go like too far, but
Right. Yeah,
I would say
so
you would be
overview,
fine.
yeah.
You would be fine.
You would be fine if you had your property in a trust. So is that something that you suggest to your clients, that they put their property in a trust?
I don't really like land trust because, and some people do. I've met attorneys who do because of the maintenance issues and the fees that you have to pay to the recorder of deeds office every single year.
Okay.
I know most of my clients use a flexible business structure called a limited liability company, and they put the property with the limited liability company. And if you don't want someone to, know that you're a member of the company, there's ways around that too, to be able to still obscure title and protect the property.
So land trust is a tool to protect your property, I imagine, against outside entities that may want to take it from you, right? Or gain some sort of ownership from something that you own, be it family, be it someone that's attempting to sue you. Land trust can help protect that property.
That is correct.
Okay, got it. And in closing, there's one other thing I wanted to discuss before we go, and that was power of attorney. Can you tell Realtist Nation what power of attorney is and how it applies to a real estate transaction?
Definitely. I see limited or power of attorneys, what we call a limited power of attorneys, utilized in real estate transactions where generally in the sale, right? Because the buyer has to sign so many documents, but the seller can't attend the closing, and they generally provide their attorney with what's called limited power of attorney. It's a document that's drafted by the attorney, the seller's attorney, and it is signed by it's a legal document that gives the seller's attorney authority to act on their client's behalf, and it's usually signed in front of a notary, and the client signs it in front of the notary, and the attorney brings it to the closing location, to the title company, and provides the documentation to the closer for their records. And from there, right, the attorney is then authorized to be able to sign all documents necessary to complete the transaction in question. It's usually limited to the one transaction in question.
To the one transaction. So if I give you power of attorney over my property, that doesn't mean you own the property. Does it, like, if you close, does that mean you get keys to my property and I don't own it? It just means that you have, I've given you permission to sign documents on my behalf to close the transaction on the property. Exactly.
And the client receives a copy of the power of attorney, and they go through it with their attorney, right? Which is, this is a good reason about having an attorney.
Right.
And the agreement is very specific, and it'll talk about what the attorney can do on your behalf. So, you could rest assured, right? So long as what that agreement says, you know that your attorney is going to act in your best interest, and any decent attorney would act in their client's best interest.
So this is a notarized document. We can't just speak on the phone and I say, hey, Cal, I'm not going to be able to make it. Could you show up for me? This is a document that has to be signed in front of a notary, correct?
That is correct.
Okay.
And a witness.
Outstanding.
Yeah.
Well, I want to thank you for coming to the Realtist Report today. You've given Realtist Nation some great information about why you need an attorney to work with you on purchasing or selling any type of transaction in real estate. This is Calvin Boyd of Boyd LLC. Again, thank you. Realtist Nation thanks you. I'm your host, Darryl Powell Lee, and the best estate is real estate.
Thanks for having me.
Thanks for coming.